Eastern Cape, Ms. Judith Steyn, Public Protector South Africa staff, members of the media, ladies and gentlemen, I greet you all this afternoon. I would particularly like to thank the media for honoring this invite. This is very important to us. As the media, you play a key role in transmitting our message to the general public. You too are an integral and critical part of strengthening our democracy. Before going into our investigative work, I wish to take this moment to introduce to you the Public Protector South Africa new CEO, Mrs. Thandi Sibanyoni. She is joining us virtually from the head office in Pretoria. Today marks a full month since she joined this institution, although it already feels like forever. Mrs. Sibanyoni brings a wealth of public service experience which extends over a period of 30 years, 20 of which were in a senior management position. She is a seasoned bureaucrat who for the past 14 years served at the South African Social Security Agency as a Deputy Director General, responsible for various portfolios including fraud investigations, internal audit, corporate services, as well as serving as Provincial Manager of the SASSA in the Northern Cape. We further wish to thank the former acting CEO, Ms. Yalekile Lusibane, who has now resumed a position as the Chief Financial Officer. Prior to Ms. Sibanyoni's appointment, Ms. Lusibane held the fort as Accounting Officer and did a sterling job. She ran a tight ship in the 13-month period during which we set a new record for ourselves with our first ever clean audit. Coming back to the business of the day, we call this media briefing to update the people of South Africa on the outcomes of some of the investigation work that we carried out during the 2020-2021 financial year, which comes to an end today. As you may be aware, the public release of our investigation findings is a constitutional and legislative injunction under Section 182, subsection 5 of the Constitution, read with Sections 8, subsection 1 and Section 8, subsection 2, capital A of the Public Protector Act 23 of 1994. Today, we shall be releasing 21 reports, 10 of which are closed investigations. We wouldn't have been able to release these reports without the outstanding dedication and hard work of the investigators of Public Protector South Africa. I wish to thank and congratulate Public Protector South Africa staff for having gone the extra mile to finalize approximately 6,700 of about 8,600 cases as at 28 February 2021 under stringent conditions, not only brought about by the limited resources at our disposal, but exacerbated by the COVID-19 pandemic in the past year. This is not only by the outbreak of this killer virus itself, but the corruption pandemic that confronted the country, stemming from measures put in place to curb infections and save lives. Unfortunately, some in society saw this as an opportunity to pillage the public purse for personal gain. This led to an increase in our investigations. I wish to briefly provide a bird's eye view of the state of governance in the country based on our analysis of the matters that the office has dealt with during the financial year ending today. We observed the following amongst others: lack of integration in government systems, widespread failure to comply with the law, policies and regulations, especially when it comes to appointment of staff and procurement, and lack of responsiveness. We call on government to pay attention to these and many other issues we will be referring to in this briefing. I now turn to our findings in respect of the various investigations that we have finalized since the last batch of reports we issued last month. At the very outset, I would like to point out that in all of our investigations, we follow the same approach. We start with the question, what happened? To answer this question, we carry out a factual inquiry relying on the evidence provided by the parties and that which is independently sourced during the investigation. We then set out to establish what should have happened. During this part of the investigation, we focus on the law or rules that regulate the standard that ought to have been met by the organs of state concerned to prevent maladministration. We then bring what happened and what should have happened together to establish whether there is a discrepancy between the two. Ideally, there shouldn't be a discrepancy. However, if there is, we determine what that discrepancy amounts to maladministration. In the event of maladministration, we determine what it would take to appropriately remedy the wrong or to place the complainant as close as possible to where they ought to have been but for the maladministration. I now proceed to the investigation reports, starting with the closed matters, which are as follows. An own initiative preliminary investigation into information that 2 of the companies from which COVID-19 related products were procured by the KwaZulu-Natal Department of Education, namely Alfred Trading and Mavuka 010115 Trading, might not have been registered on the National Treasury Central Supplier Database as required by the National Treasury Instructions, report number 30 of 2020-2021. No evidence in this matter of wrongdoing could be found. An investigation into alleged contravention of Regulation 27, subsection 2 of the Disaster Management Act of 2002 by Mr. Mzwandile Masina, the Executive Mayor of the City of the Ekurhuleni Metropolitan Municipality, report number 34 of 2020-2021. Public Protector South Africa had no jurisdiction to deal with this matter. A report on a review application by Mr. Charles Kendall in terms of Section 22, subsection 4.1 of the Housing Consumers Protection Measures Act 95 of 1995 in respect of R1183 Glen Erasmia Extension 14, report number 35 of 2020-2021. Application dismissed on the basis that the allegations against the National Home Builders Registration Council were not substantiated. An investigation into allegations of undue prohibition of Kabido Trading and Projects Pty Ltd to render specific performance in terms of the contract by the Agricultural Research Council, report number 39 of 2020-2021. Public Protector lacks jurisdiction to investigate contractual matters. An own initiative investigation into alleged maladministration in the procurement of personal protective equipment by the Free State Provincial Government. No evidence of wrongdoing was found on the aspects which the subject of our investigation was based on. The SARS and SIU are investigating further on the other aspects in the matter. An investigation into allegations of undue delay and of failure by SASSA to pay social grants to beneficiaries, as well as failure to properly implement new grant payment system regulated by the South African Police Office. Report number 45 of 2020-2021. The allegations were found to be unsubstantiated. An own initiative investigation into allegations of maladministration by the Housing Development Agency relating to the construction of transitional residential units at Dalana Hostel, Zanin. A supplementary report was subsequently issued in this matter in terms of applicable case law, in which we cured an inaccurate statement initially made. The SIU and the Hawks are also investigating this matter, and arrests have already been made, thus this matter is now a subject of court. An investigation into allegations of maladministration, corruption, collusion, theft, forgery, and defeating the ends of justice by the Deputy Director General of the Department of Agriculture, Forestry, Fisheries, Mrs. Pogazindu Dane, report number 51 of 2020-2021. DAF addressed the matter internally, and the bribery allegations are being investigated by the Hawks. An investigation into allegations of maladministration by the Automotive Industry Development Center in connection with the irregular appointment of staff. Part of the allegations is unsubstantiated, and the other part has been dealt with internally. An investigation into allegations of improper conduct by the University of Pretoria to exclude Ms. T.K. Chimbwanda during the selection process for a Bachelor of Social Science Honours Program in Psychology, report number 56 of 2020-2021. Allegations were found to be unsubstantiated. I now turn to deal with the formal reports in which we made findings and where necessary took appropriate remedial actions. In the matter of Lesufi versus the Department of Military Veterans, report number 32 of 2020-2021. We investigated allegations of undue delays and improper prejudice by the Department of Military Veterans to register Mr. M.L. Lesufi on its database. The investigation followed a complaint from Mr. Lesufi. We found that the department unduly delayed to register Mr. Lesufi on its database as per the ruling of the Military Veterans Appeal Board. We also found that the department failed to implement the ruling of the Appeal Board, which found that the appeal succeeds and that the department must register Mr. Lesufi in its database with immediate effect. We further found that the department failed to provide Mr. Lesufi with reasons for its failure to implement the ruling of the Appeal Board or of its decision to take the board's ruling on review. Mr. Lesufi suffered prejudice as a result of the conduct of the department. To remedy the maladministration, the Director General of the department must, within 60 working days of the date of the report, conduct an internal investigation into the matter and take appropriate action. He must further register Mr. Lesufi on the department's database with immediate effect as per the Appeals Board ruling. The DG must also tender an apology to Mr. Lesufi for the undue delay to register him on the department's database and the prejudice he suffered as a result. This must happen within 1 month of the date of this report. In the matter of Sarah versus Magareng Local Municipality, report number 50 of 2020-2021, we investigated allegations of improper conduct and maladministration relating to the sale of ERF 886 to Ms. Doreen Saray by the Magareng Local Municipality in the Northern Cape Province in 2006. The investigation resulted from Ms. Saray's November 2015 complaint. We found that the municipality failed to transfer F886 into the name of Ms. Saray and to provide her with the title deed. To remedy this maladministration and improper conduct, the mayor must, among other things, take the appropriate steps in terms of the applicable laws and other prescripts to engage with Ms. Saray on the allocation of alternative land to her, should she be amenable thereto, and if so, that a report is to be submitted to council for a decision in this regard within 60 days of the date of this report. The mayor must also apologize in writing to Ms. Saray for the delay in providing her with the title deed of F886 that she purchased from the municipality and the prejudice that she suffered as a result thereof, within 30 days of the date of this report. Makgoba versus the University of Limpopo, report number 53 of 2020-2021. We investigated allegations of maladministration relating to the failure by the University of Limpopo to deduct and pay the employer of the university's pension contribution in respect of Mr. F.M. Makgoba, a former employee of the university. The investigation was prompted by an April 2018 complaint by Mr. Makgoba. We found that the university failed to conduct and pay the employer and employee's pension contribution into the Provident Fund. Mr. Makgoba was prejudiced. To remedy this maladministration and improper conduct, Mr. Makgoba must pay over his employee's pension fund contribution in the amount of 40,748 Rand 80 into the university's main bank account within 30 days of the date of this report, as per the agreement reached at the meeting held with the Public Protector South Africa on the 3rd of March 2021. The university must then recalculate the employer's pension contribution and pay over both the employer and employee's contributions to the fund within 60 days of the date of this report. In the matter of Dubenar versus the Compensation Fund, report number 57 of 2020-2021, we investigated allegations of failure by the Compensation Fund to revise the 2013 assessment of executive apartments and hotels, Pty Ltd. The investigation came about as a result of a November 2018 complaint by Ms. Yvette Dubenar, an employee of Quiet Support Pty Ltd. She lodged the complaint on behalf of Executive Apartments and Hotels Pty Ltd. We found that the Compensation Fund improperly declined to revise Executive Apartments and Hotels Pty Ltd's 2013 assessment upon request. We have taken note that the Compensation Commissioner has taken a decision to accept the company's application for the revision of the 2013 assessment. As stated in the response to the Section 79 notice, which was earlier addressed to the Commissioner, and that the Commissioner has committed to start the process of revision as at 10 March 2021. In terms of appropriate remedial action, the Commissioner must, within 30 days from the date of this report, ensure that the process of revising the employer's assessment for the year 2013 is finalized and furnished to the Public Protector South Africa and Executive Apartments and Hotels Pty Ltd with the outcome of the revision thereof. In addition, the Commissioner must ensure that all the interest accrued and levied on Executive Apartments and Hotels Pty Ltd's account is reversed and issued a written apology to the company within 30 days from the date of this report for the inconvenience and prejudice that the company suffered as a result of the refusal by the Compensation Fund to revise the 2013 assessment. In the matter of Kekana versus Tembisile Hani Local Municipality, report number 36 of 2020-2021, we investigated allegations of maladministration and improper conduct by the Tembisile Hani Local Municipality in Mpumalanga for improperly charging Mr. Amin Tente Kekana for basic services consumed by the previous occupant or owner of the house he subsequently purchased. Mr. Kekana, who resides at stand number 1636 Sun City A, Kwamhlanga, 1022, approached the public protector in May 2018, alleging that the municipality incorrectly held him liable to pay an outstanding services bill of the previous occupant of the property which he eventually bought. The investigation revealed that the municipality improperly billed Mr. Kekana for services which were rendered before the property was legally transferred to him. The municipality failed to provide any record that confirmed that Mr. Kekana was formally informed that an amount of 18,282 rand would be added as an accumulated debt for services rendered to the property he was purchasing in 2013. To remedy this improper conduct and maladministration, the municipal manager must ensure that Mr. Kekana is refunded an amount of 18,282 rand plus interest calculated in terms of the prescribed rate of Interest Act 55 of 1975 within 60 working days from the date of this report. The municipal manager must also apologize in writing to Mr. Kekana from improperly billing him for municipal services which were rendered before the property was legally sold and transferred to him. Samu versus Vhembe District Municipality, report number 37 of 2020-2021. We investigated allegations of abuse of power by the former municipal manager of the Vhembe District Municipality, Mr. M.R. Rambado, in the appointment of Ms. L. Sikororo and Ms. N. Ramabanda to the positions of Response and Recovery Coordinator PL4 and Land Use Management Officer PL4, respectively. The investigation followed a June 2018 complaint by the South African Municipal Workers Union, SAMU. We found that Mr. Rambado abused his power by instructing the interview panel to appoint Ms. Chikororo and Ms. Ramabanda to the positions of Response and Recovery Coordinator, PL4, and Land Use Management Officer, PL4, respectively. Mr. Rambado provided the panel with a piece of paper with the names of his preferred candidates, namely Ms. Chikororo and Ms. Ramabanda, and he instructed the panel to appoint them. To remedy this improper conduct and maladministration, the executive mayor must table this report before the municipal council for a decision on how to deal with the irregular expenditure and take appropriate steps to institute proceedings for the judicial review of the irregular appointment of Ms. Chikororo and Ms. Ramabanda. Additionally, the municipal manager must take disciplinary action against current employees who were party to the irregular appointment of Ms. Chikororo and Ms. Ramabanda. Disclose all irregular expenditure incurred in connection with the irregular appointments of the two employees. Report the irregular expenditure to the provincial treasury. Train and create awareness to all employees on the recruitment policy and ensure compliance thereto to avoid a recurrence. All these steps must be taken within 60 working days from the date of issue of this report. Eastern Cape Department of Health, report number 52 of 2020-2021. This is an own initiative investigation on allegations of improper conduct and maladministration by the Eastern Cape Department of Health in connection with the procurement of motorbikes with a sidecar ambulance or clinic. The investigation commenced on 14 July 2020 on the grounds of information that came to the attention of the public protector from media reports on the launch of what was referred to as, I quote, scooter ambulances, I unquote, by the Eastern Cape Department of Health on 12 June 2020. We found that the procurement process followed by the Eastern Cape Department of Health when it awarded FAPCOM contract number SCMU 3 2020-2021 0022HO to supply motorbikes with the sidecar ambulance or clinic was improper and in contravention of applicable legal prescripts. The Eastern Cape Department of Health contravened or did not observe relevant provisions of the Constitution, the PFMA, Treasury Regulation 16 capital A 6.3C, Treasury Regulation 16 capital A 6.4, relevant paragraphs of the National Treasury Instruction 3 of 2016-2017, Treasury SCM Instruction 2 of 2016-2017, and relevant paragraphs of the Eastern Cape Department of Health Supply Chain Management Policy in the process of this procurement. To remedy this maladministration and improper conduct, the acting head of the Eastern Cape Department of Health must take appropriate steps in respect of disciplinary action in terms of Section 38H of the PFMA and the applicable policies of the department against the officials that were involved in and responsible for the non-compliance with the provisions of the SCM policy and Treasury regulations pertaining to the procurement of the scooter ambulances or clinic within 90 days of the date of issue of this report. The acting head must also ensure that all the officials involved in SCM processes and the senior managers of the department attend a workshop on the relevant legislation and other legal and policy prescripts and instructions of the national and provincial treasuries regulating the procurement of goods and services by the department within 60 days of date of issue of this report. The MEC for Health must oversee to ensure that appropriate steps are taken in respect of disciplinary action in terms of Section 38H of the PFMA and the applicable policies of the department against any decision makers, regardless of position, across all the ranks of seniority that were involved in and responsible for the non-compliance with the provisions of the SCM policy and Treasury regulations pertaining to the procurement of the scooter ambulances or clinics within 90 days from the date of issue of this report. In the matter of Anonymous and others versus Eastern Cape MEC for Transport, Safety and Liaison, Provincial Departments of Health and Public Works and Infrastructure, report number 40 of 2020-2021. We investigated allegations of improper conduct and maladministration by the Eastern Cape MEC for Transport, Safety and Liaison, Ms. Weziwe Tikana Qotiwe, and the Provincial Departments of Health and Public Works and Infrastructure relating to the procurement of goods and services. A complaint was launched on 20 May 2020 by an anonymous member of the Eastern Cape Provincial Legislature of the Economic Freedom Fighters Provincial Party, requesting that we investigate the procurement of goods and services by the Eastern Cape Department of Transport, Safety and Liaison from the CITA events and the procurement of accommodation to quarantine COVID-19 patients at Mioka Lodge. The complainant requested that we investigate the relationship between the MEC, Mioka Lodge, and Ukhanyo Travels and whether contracts were awarded to these entities due to MEC's influence and relationship with them. On 7 July 2020, the Public Protector South Africa received another joint complaint from Dr. Lwazi Nkapaye of Kalusa and General Bantu Bonke Holomisa MP of the United Democratic Movement in connection with the procurement of accommodation at Mioka Lodge to quarantine COVID-19 patients. In addition to the request for investigation referred to above, it was alleged that on 15 April 2020, the Provincial Public Works Department, the Provincial Health Department, and the Provincial Executive Council took a decision to accommodate 18 COVID-19 patients at Mioka Lodge in the Kala Reserve area owned by the daughter of the MEC, which resulted in a conflict of interest on the MEC's part, as she was alleged to be the true owner of the Mioka Lodge and has substantial interest in it. We found that the MEC was not improperly involved with Ukhanyo Travel and Events, SITA Events, Mioka Lodge, and Vexobite, and did not influence the awarding of tenders to them by provincial government departments. Although the investigation established that Mioka Lodge and Vexobite are owned by the MEC's daughter and husband respectively, it could not be found from the evidence obtained during the investigation that the MEC was involved or influenced the procurement of Mioka Lodge as quarantine site for COVID-19 patients. Neither was the evidence which reveals that the MEC influenced the awarding of tenders to Vexobite, SITA Events, and Ukhanyo Travels. No substantive information or evidence for these allegations were provided or could be found. The evidence further reveals that the MEC duly declared a relationship with Mioka Lodge, and her husband declared his relationship with the MEC in respect of the bid submitted to Vexobite, by Vexobite rather. We, however, found that the supply chain management processes followed by the Departments of Health and or Public Works and Infrastructure when it identified and procured accommodation from Mioka Lodge for COVID-19 patients to quarantine was in contravention of applicable laws and legal prescripts regulating procurement. To remedy this improper conduct and maladministration, the Provincial Health HOD must take appropriate steps in respect of disciplinary action against the Director for the Chris Hani District of the Department, Ms. N. Kiza, in connection with her role in the irregular procurement of accommodation for COVID-19 patients and the fruitless and wasteful expenditure incurred as a result thereof. This must take place within 60 days from the date of issue of this report. The HOD must take appropriate steps to recover the fruitless and wasteful expenditure incurred by the department in transporting the COVID-19 patients to and from Mioka Lodge in terms of regulations 9.1 and 12 of the National Treasury Regulations within 60 days of the date of issue of this report. In addition, the Provincial Public Works HOD must take appropriate steps in respect of disciplinary action against the Regional Director for the Chris Hani region of the department, Mr. Z. Galako, for his role in the irregular procurement by the Provincial Public Works Department of accommodation at Mioka Lodge for COVID-19 patients within 60 days of the date of issue of this report. The HOD must also take appropriate steps to ensure that all the SCM officials of the department attend a workshop on the legislation, regulations, policies, and other relevant prescripts regulating SCM in the department within 60 days from the date of this report. In the matter of Heron versus Madikizela, Report number 49 of 2020-2021, We investigated allegations of a breach of the Executive Ethics Code by the member of the Executive Council for Transport and Public Works of the Western Cape Provincial Government, Mr. B. Madikizela. The investigation followed a November 2019 complaint by Mr. B. Heron, a member of the legislature. Mr. Heron alleged that Mr. Madikizela willfully made false and misleading statements to the legislature about him on 23 July 2019, and that conduct in question was improper and constituted a breach of the Executive Ethics Code. We found that MEC Madikizela willfully made false and misleading statements to the legislature about Mr. Brett Heron. The MEC's conduct in this regard constituted a breach of the Executive Ethics Code. As an appropriate remedy, the Premier of the Western Cape must, in terms of Section 3, subsection 6 of the Executive Members' Ethics Act, within a reasonable time, but not later than 14 days after receiving this report, submit a copy thereof and any comments thereon, together with a report on any action taken or to be taken in regard thereto to the Western Cape Provincial Legislature. In the matter of Sithebe Dlamini versus Chris Hani Baragwanath Academic Hospital, report number 46 of 2020-2021, we investigated allegations of maladministration and improper conduct by the Chris Hani Baragwanath Academic Hospital in Gauteng for its failure to inform the Sithebe family of the death of Mr. Themba Milton Sithebe, the subsequent loss of the deceased corpse, as well as the failure by the South African Police Services to investigate or finalize the case of a missing corpse. The investigation stems from a complaint lodged with the Public Protector in October 2018 by Ms. Nokuthula F. Sithebe Dlamini, the deceased niece. We found that there was maladministration and improper conduct on the part of the hospital and its alleged failure to inform the Sithebe family of the death of their family member and the loss of the corpse. However, the allegations that the subs failed to investigate the case of the missing body of Mr. Sithebe is unsubstantiated. We also found that Ms. Sithebe Dlamini and the family suffered prejudice as a result of the conduct of the hospital. However, the allegation that she or any other person suffered prejudice as a result of the conduct of subs is not substantiated. As part of appropriate remedial action, the acting head of the Department of Health, Mr. Arnold Lesiba Maladona, and the Chief Executive Officer of the hospital, Dr. Nkele Lesia, must ensure that a register system containing information which expressly indicates the full names and designations of officials at the wards and detailed information regarding who is responsible for patients from entry to the exit of the patient in the wards is put in place. The data register must clearly show a chain of events in the wards, the date, the time, details of patients involved, and all the staff involved in the handling of the patients at the wards. Mr. Malotana and Dr. Lesia must also ensure that the staff is trained on the data on the database of the hospital register, specifically complying with the completion of the register. They must further initiate a disciplinary process against Sister Maile, who was responsible for, among other things, the violation of the Births and Deaths Registration Act, the regulations relating to the management of human remains, and those on the rendering of forensic pathology services. All the above must take place within 60 days of receipt of this report. In addition, they must issue a formal written apology to Ms. Sithebe Dlamini regarding the hospital's failure to inform her about the death of Mr. Sithebe and the subsequent loss of his corpse. This must happen within 30 days of the date of this report. The matter of Bellville Magistrates Court, report number 55, 2020-2021. We investigated allegations of improper conduct and maladministration by the Bellville Magistrates Court relating to an application for a protection order. The investigation followed a June 2020 request by the Deputy Minister of Justice and Correctional Services, Mr. John Jeffrey, MP. The Deputy Minister requested that we investigate allegations reported in the news media that Ms. Altasia Korcha approached the court to apply for a protection order, but was turned away by the court officials. According to the media reports, Ms. Korcha was allegedly murdered by her former partner on 12 June 2020. In essence, it was alleged that the failure by the officials at the court to assist Ms. Korcha with her application for a protection order was improper, constitutes maladministration, and prejudiced her and her family. From the evidence obtained during the investigation, it is concluded that the late Ms. Korcha visited the court around midday on the 8th of June 2020 to apply for a protection order in terms of the Domestic Violence Act. Her name was placed on the list of complaints at the protection order section of the court. She was attended to by a clerk who provided the application form to her to complete and provided her with an explanation in connection with her application, the involvement of social workers, and that the respondent would have to appear in court. According to the evidence of the two senior administrative clerks that were on duty on the day at the protection order section on 8 June 2020, they could not specifically remember the late Ms. Korcha, but they followed the same procedure in respect of applications for protection order as they do on the ordinary course of their duties. It was also evident from the records of the court that several applications were processed on the 8th of June 2020 and the interim protection orders issued. Ms. Korcha left the court about an hour after her arrival without having completed and submitted the application form for further assistance. Her explanation to Ms. N.G. Dolph, who had accompanied her to the court on that day, was that she did not expect that it would be a long process to obtain the protection order, and there was too much to write. It was not clear whether Ms. Korcha intended to complete the form and return it to the court with her application. According to her mother, the late Ms. Korcha had to go to work the next day and did not return home on 10 June 2020. She was later found deceased. There is no evidence indicating that Ms. Korcha was turned away by the court when she wanted to apply for the protection order. The evidence shows that she was assisted at the protection order section and requested to complete the prescribed application form. She also did not indicate to Ms. Dolph or her parents that she was not assisted by the officials at the court to complete the application process. It could not be established with certainty why Ms. Korcha decided not to wait to be assisted with submitting application after having completed the form, but to return home. The evidence obtained from the investigation does not support the allegations that Ms. Korcha was turned away or not assisted by the Bellville Magistrates Court. When she wanted to apply for the protection order on the 8th of June 2020, there was thus no improper conduct or maladministration on the part of the court. However, this morning, we visited the family of Ms. Korcha in Delft, not far from where we are. We communicated to them the contents of this report and assured the family that the tragic passing of Ms. Kortsche and her daughter, Renasia, has spurred us on to take up the cudgels on behalf of all other victims of gender-based violence in society. I shall later dwell on this. As I conclude on investigation reports, the office looks forward to the full implementation of the appropriate remedial action taken in respect of the above investigations. Accordingly, we would like to remind all the affected organs of state that today marks 5 years since the Constitutional Court handed down the Economic Freedom Fighters versus the Speaker of the National Assembly judgment. As you will recall, in that seminal ruling, the Constitutional Court held that the remedial action taken by the Public Protector is binding unless set aside by a court of law. Of relevance in this regard is the following passage in the judgment. I quote, "When remedial action is binding, compliance is not optional. Whatever reservations the affected party might have about its fairness, appropriateness, or unlawfulness, for this reason, the remedial action taken against those under investigation cannot be ignored without any legal consequences." I unquote. Full copies of the report in respect of each of these matters can be accessed on the Public Protector South Africa website. In addition, all the affected and interested parties have been furnished with copies. As we prepare to begin the 2021-2022 financial year, which commences tomorrow, our approach is to be developmental in our work and optimize our impact in ensuring a strengthened governance system to build a capable state. One of the key projects for the year is a systemic investigation in honor of Ms. Kortsche, her daughter Renasia, and many other victims of gender-based violence across the country. It will be a nationwide investigation into the systemic challenges that plague the justice value chain to fight gender-based violence. That will be one part of the investigation. The other part will look into the systemic challenges pertaining to child maintenance, which is also a cause of concern. We have previously dealt successfully with a case of a distraught young mother in this province who struggled with child maintenance, even though the courts had ruled that areas and future maintenance benefits be deducted from the defaulting father's pension fund. The child maintenance aspect of the investigation was also inspired by a cry for help which we came across on a Facebook post. In the post concerned another distressed mother laid bare how maintenance court experience, demonstrating how women and children experience secondary victimization in the system and how humiliating the process is. The post read in part, I quote, "I decided to set up office here and arrived just after 7 a.m. They open at 7:45 a.m. I was second in line and decided to open my iPad and do my work while I wait. The maintenance clerk are friendly to me. They know me by my first name. One of them even knows my case number off by heart. I fill in the form, which I have filled in for the nth time now. The bank statements reveal that we are 25,000 rands in arrears. I show them the famous R1 deposit which made an appearance in April, May and June months later last year. This time the clerk is not seeing anything funny about the 1 rand deposit, but I laugh it off anyway. It's my journey. It's what I know and have been violently made to accept. I see that I have waited for quite some time to come here again. Maybe I was consumed with getting my health in order last year. I continued with what I needed to do, or maybe I was just too tired. Here's the issue now. I must convince the court not to allow my child to stand against his father in court. He has turned 18. He is in matric and does not need added pressure on him. The criminal justice system in its current form needs to be dismantled. It cannot be that it forces children to go into battle with their biological fathers. What about relations after the court has made its decision? What if the father brings the most expensive legal team to court, a right he has? Where should an 18-year-old get such assistance? I unquote. Through this investigation, we will seek to see to it that the system that is currently in place to assist victims of gender-based violence and intervene in child maintenance system is less cumbersome, more welcoming, accommodating, and relevant to the material conditions, as well as user-friendly. This systemic investigation is but one of two that we must, in terms of the 2020-2022 annual performance plan, which we tabled in Parliament 2 weeks ago, pursue in earnest from tomorrow. The other focuses on serious basic service delivery deficiencies that appear to have plagued communities across the Eastern Cape. It was prompted by an overwhelming public outcry during a phone-in program on SABC Radio, Umhlobo Wenene FM, recently. In the program, during which I was a guest, a myriad of infrastructural and basic services complaints were brought to our attention. They include alleged lack of water supply, bridges, electricity, social welfare, and housing. To this end, we would like to say to the people of the Eastern Cape that we have heard your cries. We are going to get to the bottom of the systemic lapses that give rise to the service delivery problems you continue to experience. By this day next year, we ought to have finalized at least one of these two massive investigations. The two investigations are over and above other investigations-related targets, such as adherence to set turnaround times, with a view to ensuring reasonably expeditious justice and clearing the case backlog by ensuring all active matters that have had a lifespan of more than 2 years in our system are disposed of. Finalizing a set number of formal investigation reports and holding, dear colleague, meetings with organs of state where systemic challenges that give rise to maladministration appear to be rife are two other investigations-related performance targets for the year. In addition, our investigations in relation to the state of health care facilities across the country remains on course. And so does the intervention in the problems plaguing the higher education landscape, in which we have joined forces with the South African Human Rights Commission. Also ongoing are some of our COVID-19 related investigations. The developmental aspect of our mandate requires us to carry out these investigations to look at and remedy the broader impact of maladministration and system failure in state affairs. We will finalize and issue reports stemming from these investigations in due course. As I conclude, I would like to thank stakeholders for this unwavering support that they have provided us during this period. This includes respondents across the public administration, such as in the Department of Home Affairs, who cooperated and responded timelessly when we requested information in connection with our investigation work. We'll also remember that the Minister of Home Affairs, Minister Aaron Motsoaledi, made a public statement embracing our remedial action and making a commitment to comply with them. We are also encouraged that Premier Ellen Vinde of the Western Cape Province implemented the remedial action taken in the report on an investigation into allegations of a breach of the Executive Ethics Code by the Provincial MEC for Local Government, Environmental Affairs and Development Planning. In the same breath, we are pleased that the Tatabane local municipality in the Northern Cape also implemented our remedial action in respect of the investigation into allegations of improper conduct and maladministration relating to temporary appointment of the manager, strategic support, and 3 ward committee clerks. There are several other organs of state that should be commended and emulated for implementing our remedial action. Further, the following reports are either fully implemented or at an advanced stage of full implementation. The report on an investigation into allegations of maladministration by the South African Police Service with regard to its handling of an appeal against the dismissal of Constable Boitumelo Godfrey Mohelebangu, Report 8 of 2019-2020. A report on an investigation into allegations of irregular procurement of official vehicles for the former Premier of Mpumalanga Province, Honorable David Mabuza, by the Mpumalanga Office of the Premier, Report 10 of 2019-2020. Report on an investigation into allegations of maladministration and undue delay by the Department of Military Veterans in the registration of Mrs. M.L. Kulube, BP Nevondo and TM Makunga on its database, Report 12 of 2019-2020. Report on an investigation into allegations of undue delay and maladministration by the Compensation Fund with regard to the processing and payment of the compensation benefits to employees of private employers, Report number 14 of 2019-2020. Report of investigation into allegations of maladministration, corruption, and nepotism against the former CEO of the Agricultural Sectoral Education Training Authority, Mr. Jerry Madiba, Report 18 of 2019-2020. Report on an investigation into allegations of undue and improper prejudice by the Department of Water and Sanitation relating to the application for water use license application by Mr. N. MacDonald, Report number 26 of 2019-2020. Report on an investigation into allegations of maladministration by the erstwhile Department of Rural Development, Land Reform, currently the Department of Agriculture, Land Reform and Rural Development, to allocate approved funds for the recapitalization and development of portion 1 of the Farm Crocodile Spruit 290 JR, Report number 29 of 2019-2020. Report on investigation into allegations of improper conduct and maladministration by the Department of Correctional Services relating to the payment of pension benefits to the mother of a deceased employee, Mr. Singapi Filifani, Report number 44 of 2019-2020. Report on an investigation into allegations of alleged maladministration, tender irregularities, and appointment by the Ekurhuleni Metropolitan Municipality, report number 62 of 2019-2020, and report on an investigation into allegations of improper conduct and maladministration by George Local Municipality relating to the appointment of the manager, Sewa Network, Johan van Schalkwyk, report 35 of 2019 2020. The same word of gratitude goes to the Department of Justice and Correctional Services for entrusting us with an investigation into the affairs of its own portfolio. This is the kind of cooperation which is desirable between the executive and constitutional institutions to improve public administration in the interest of all South Africans. However, there is still a lot of work to be done in terms of ensuring cooperation across the board. We noted the announcement of a forensic investigation into the affairs of the National Arts Council by the Minister of Sport, Arts and Culture, Mr. Nathi Mthethwa. We will contact the Office of the Minister because we have issued a report on governance issues at the National Arts Council already, and the implementation of that report might resolve some of the concerns. This approach may save the state a lot of money. Having looked at our work, it is clear now more than ever before that our mandate is crucial in helping government eradicate corruption and, above all else, in building a capable state that is accountable, that operates with integrity, and is responsive to the needs of the people. In closing, my 2.5 stint as the acting public protector comes to an end today. I would like to thank the public protector for entrusting me with the mammoth task of steering the ship while she took a well-deserved break. It has indeed been a rewarding experience. It would not have been so if it was not for the professional, devoted, and knowledgeable Public Protector South Africa staff, whom I wish to thank for the unwavering support they gave me since I took up office as the acting Public Protector in the middle of January 2021. Let's stay on this path, colleagues. We have proven to be stronger and more effective together. We look forward to welcoming the Public Protector back from her leave so that under her guidance, we can carry on with the implementation of the Public Protector Vision 2023, an ambitious plan through which we seek to take the services of this institution to the grassroots level of our communities. Once again, we convey our deepest condolences to the Public Protector, whose mother, Ms. Martha Geli Mkhwebane, passed away on Sunday. We send her and family prayers and wish them strength during this difficult time. May the soul of the Mkhwebane matriarch rest in peace. I thank you.
Thank you, Acting Public Protector. At this point in time, I will now take questions from the colleagues in the room. We have also invited the colleagues who are following these proceedings online to also channel their questions via our WhatsApp group, but at the last check, there were no questions coming through that channel. So let's see in the house if there is a question for the panel by a show of hands. Okay, there's a ENCA at the back there, and then Newsroom Africa. Let's start with ENCA. Please introduce yourself and then